To be quick there. Thank you very much for both of your contributions. It has it's as helpful and confusing each time I have one of these sessions. So I think I have a question and I confuse myself. So our main goal here is to make sure that, you know, looking retrospectively, making sure that that pathway to parenthood that you speak about is something that this committee looks at, and make sure that we have family protections, the existing family protections, but and then also going into future. But I suppose some of the questions have already been asked. But is there a process for that pathway if there was an immediate acknowledgement of parenthood? Is there a process for that to be revoked? And what happens if indeed that is deemed after the fact that it was unethical? And what happens to that baby if indeed then the surrogate says, well, I am just that, I am just the surrogate, this is not my baby? Where does that baby end up if there is questions on the ethical if it was an unethical process? And with regard to ethical international surrogacy and ethical surrogacy in general, is there a checklist? Maybe it's a naive word to say, but is there a checklist, a general requirements, things that must be done to ensure that all parties are taken care of in the partnership? And again, for that pathway to parenthood, you know, again, is there, for the want of a better word, a checklist for that judge to be able to award that parental order? Yeah, thank you. That's it so far. Thank you.
Do you want me to start this time? In terms of the first question, if the intended parents acquired automatic legal parenthood at birth, and then later, subsequently, something was found to have been unethical or wrong with the arrangement, then they are the ones who have legal parenthood. The surrogate, if it's past that window of opportunity where she has the right to withdraw her consent to them having legal parenthood, if that comes into force, then they would be parents in the same way that anyone who becomes parents are parents. And we have a Children Act in the UK which would protect the welfare of children, and decisions would be made, you know, under that basis if there was a question about the welfare of the child that was raised. So I think, you know, a question about the welfare of children just falls within an entirely different area of law than who is their parent at the moment of birth. On the other point, I think maybe you're conflating the difference between the parental order route and the proposed pathway to parenthood. So the proposed pathway to parenthood would only apply to domestic arrangements in the UK, as long as all what is proposed currently by the law commissions includes counselling and criminal records checks and all the other things that legal advice and all the other things that are put in place prior to the birth. And then those parents would become automatically the legal parents at birth, subject to them having a genetic link if that is retained, and all kinds of things like that. For overseas arrangements, which will inevitably still happen, then the pathway wouldn't come into play, and it would be a parental order process, in which case you're looking at a post-birth checks and balances carried out by a judge on the basis of the parental order application. And so, you know, it's just a different timing, I guess, of the checks, depending on where and how the child is born. Does that make sense?
Yeah. I suppose what we're trying to do here is make sure that we have ethical international surrogacy. And you said there that, you know, it's up to the judge then to decide whether it was ethical or not. Is there guidance for that judge to make sure, you know, is there a list of things to ensure that, you know, both all sides, you know, from the get-go, that parents must adhere to, you know, the agencies, everyone must adhere to during the process for that judge to award the parental order, or is it in just solely in judges' hands? Because I'm just wondering, what are those that list of guidance that the judge looks to?
Yeah, so I mean, we should know that judges are already doing this. Whether there's a written checklist is probably something more that Natalie could answer, but that rather than just sort of common law principles.
Yeah, I mean, essentially, whether it's pre-birth or post-birth, yes, there is a checklist. It's a question of who's overseeing that and at what stage. Okay. So with the proposed pathway that Kirsty was talking about, it's regulated surrogacy organisations that have to ensure these steps are taken, and then they certify that that has happened. And then that's what enables the parents to be recognised as the legal parents from birth. With the current system and the system that will remain for international surrogacy cases, it's about a judge looking at the criteria that are set out in the legislation. So some of those criteria relate to the eligibility of the parents. So they have to have a genetic link, that one of them has to be domiciled in the UK, they have to be over 18, etc. Another criteria is that the surrogate has to have given her full, free and unconditional consent more than 6 weeks after the birth. And I deal with these applications every day, and I can tell you that the judges take that requirement for consent very seriously. So, they want to see surrogates participate in the process. They want to make sure that, documents are properly translated if English isn't their first language, that they're notarised, signed by the right person, etc. And if there are any concerns about consent, then that will be investigated very rigorously. The court will then look at the payments, and this is where the kind of the ethical exploitation stuff comes in, because where the court is authorising payments of more than expenses, they will want a clear breakdown of the financial transactions that took place, so down to the penny, everything that was paid and what it was for. And then they will also want to understand the context around that. So who is the surrogate? Is there any suggestion she's been exploited or taken advantage of? Have the parents acted in good faith? Has there been anything illegal or immoral? And the court will kind of inquire into all of those issues and want to be satisfied about it. Now, ultimately, if you have a situation where there are issues or problems or something that's happened that the court doesn't feel is, in the best possible way, and that's very rare in my experience, I have to say, but if there is a question about the ethics of it, they will then balance that public policy against the welfare of the child, and they will be doing an exercise of kind of measuring, is this such a serious breach of public policy that the court should withhold a parental order, or is the child's welfare the paramount consideration, and should it outweigh that? Ultimately, there hasn't been a case where a parental order has been refused. So the kind of the compulsion of the judges to safeguard the welfare of the child, quite rightly, is very strong. But I would say that doesn't mean that the ethical issues are just irrelevant, that people will get a very hard time. They'll have to produce a lot of evidence. There will be kind of questions about what they've done and why and how and what happened and so on. So, it does, I think, help to nudge people in the right direction. I mean, if I do legal advice meetings with parents at the beginning of a surrogacy journey, I will say, look, if you want to make the court process as straightforward as possible, you need to show that you've taken care of your surrogate, you've asked about the screening, you've got a relationship with her, you've made sure that things were done properly, that no one's being taken advantage of. So the way the court inquires into these issues actually does have quite a positive effect in terms of kind of changing the environment in which people are conducting surrogacy internationally.
Okay, thank you very much.